All right, let's go ahead and get started. Hello, and thank you for joining us today. I'm Dr. Kathy Barrera. I am the founding economist at Prism Group. Today we're going to be talking about antitrust issues within the blockchain space, and specifically how economic analysis can be brought to bear on cases involving anti-competitive behavior and DLT platforms. As with many other activities that firms can engage in blockchain, we see that the activities that firms can engage in may have legitimate business purposes, or which increase efficiency, reduce costs, and improve outcomes for customers or consumers, or those same activities could be used in an anti-competitive way that would allow firms to collude or to somehow restrict a market. And the key is to be able to distinguish between these two cases. We know what the firm is doing, we just aren't necessarily sure whether it's anti-competitive or not. So as most of you probably know, outside of the blockchain and DLT space, economists are frequently brought in as expert witnesses in antitrust cases in order to help delineate between what is legitimate business use case versus what is anti-competitive behavior. So for example, an economic analysis might be used in order to determine whether price levels are due to collusive behavior versus whether those are just the natural industry or market. So, excuse me. Blockchain is a tricky technology to understand, and its interaction with economics is quite nuanced. We at Prism Group have been working with blockchain-based projects and platforms since 2017, and we've been carefully studying the uses of blockchain and distributed ledger technology and the benefits of these technologies. We've developed several frameworks for explaining the economic benefits of these technologies for both for consortium and in the permissionless space. And we've employed those frameworks in order to help our clients as they develop their use cases. But these same frameworks can be used in order to assess the extent to which a particular project may be using the technology for efficiency gains versus whether they're using them to gain an anti-competitive advantage. And that's what we're going to discuss today. So just as a little bit of background, Prism Group is an economic consulting firm specializing in blockchain and distributed ledger technologies. Our economics team is led by myself, Kathy Barrera, and Stephanie Herder. We both have PhDs in business economics from Harvard, went through academia, and have previous consulting experience before we started Prism Group. In addition to our consulting work at Prism Group, our team works on building out research and some educational initiatives, and those opportunities have allowed us to develop these frameworks that I mentioned in order to better serve our clients. So our consulting work itself includes, as I mentioned, doing incentive design for projects and platforms, economic auditing of designs that our clients bring to us, and we also serve as expert witnesses in litigation that's not involving our the clients that we have helped with their economics. So that's sort of an overview of our firm. For the next about 25 minutes, I'm going to talk a little bit about some of the key areas in distributed ledger technology that we believe interact with antitrust law and how we think about those issues as economists. So specifically, how would these issues play into the types of analysis that an economist might conduct if they're doing expert witness work on an antitrust case. So I'm going to start by talking about the economic benefits of distributed ledger technology, those frameworks that I mentioned earlier, in order to sort of create a baseline of what legitimate DLT activity might look like. Then we're going to talk about 3 areas where this legitimate activity might result in mechanisms that could be misused. So again, this is this area where it might be difficult to determine whether what's happening is for legitimate business purposes or for collusive or anti-competitive purposes, and sort of how the design of the platform may lead to more problematic behavior or not. So those 3 areas that we want to highlight are data transfer and information exchange, smart contracts, and standards to transfer this information. And finally, I'll speak briefly about excuse me. Finally, I'll speak briefly about how calculating damages in the context of blockchain or DLT might sometimes be a little bit different from how those would be conducted in traditional antitrust cases. And of course, I'll summarize at the end, and we will have plenty of time left over for questions and discussion. Just on a logistical note, there's a Q&A button where you can submit questions. I will be answering clarifying questions throughout the presentation portion, and I'll hold all other questions until the end of the presentation for the Q&A portion. So let's get started by talking about the economic benefits of DLT. I'm not going to spend any time talking about what is blockchain not, but instead we'll sort of go over some of these high-level frameworks that talk about how businesses can employ this technology in order to drive efficiencies for their business. So blockchain is a database technology, and it's specifically a shared database technology that has some unique features. And we believe that one of the critical features or critical reasons why business or consortium might consider using other shared database technologies that might be available is because it's resistant to holdup. So in particular, any shared database is going to be subject to the holdup problem. You'll have companies who want to work together or maintain a shared database will all have to contribute their information or their data into that system. And that means making relationship-specific investments. So if I'm a participating company, I have to convert all my data into the format that's compatible for this database. I have to make an investment in using a new type of software that allows me to interact with this database. And I may be reliant on those data standards and software in order to be able to retrieve or access the data that I have contributed. And because other shared database technologies all require a central administrator or an owner, can then be subject to holdup. That administrator or owner could take actions that put those other participants at a disadvantage. And this potential for holdup, we think, has prevented many shared databases from being developed in the first place. So due to concerns about potential future holdup, we don't create a shared database in our industry, even though we all know that having that shared database would be very useful. So we've seen in several industries blockchain projects being built to address a problem that has been known or ongoing for many years that wasn't addressed before because of this holdup issue. So there are three benefits of blockchain. This is our main framework for thinking about how blockchain is going to provide efficiencies and efficiency gains for businesses. The first benefit is coordination. So you may have heard in other contexts, folks saying that if we use a distributed ledger, we use a blockchain, then we won't have to do as much reconciliation or ex post accounting work as we would have to do using our legacy systems. That is exactly a coordination benefit for these projects. So we maintain a shared database of our transactions or our other vital information. And so we have one source to go to for that information instead of having disparate sources that we then have to make sure match. So coordination is one benefit. Commitment is a second benefit. So blockchain and related technologies like smart contracts, which we will talk about further in a few minutes, allow some business activities to be automated through algorithms or programs. So we may say we want to conduct a trade or a payment will happen when a specific good is delivered, and we can automate that. We can program it in so that that payment will be made when the software is alerted that the good has been delivered. And so this allows us to not have to rely on the goodwill of the trading partners when we can potentially, in some cases, reduce the probability that a dispute will occur over one party not fulfilling the agreement as previously agreed. And then the final benefit of blockchain, and this goes back to the issue of holdup that I was discussing before, is that the nodes that are participating in the blockchain, so if we're talking about a consortium, the major participants of the blockchain, each retain local control of their own data or their contributions. So this reduces the probability of having a holdup problem, and therefore it increases the incentive for investment in the shared database and increases the chance that these entities will join and be willing to participate in the first place. So in order to just sort of try to make highlight or make some of these benefits of blockchain more clear, I just wanted to go through a quick example. There's many examples across many industries. The one that I'm going to highlight here is a consortium in the healthcare sector that we worked with, composed of health insurance companies, as well as some major hospitals and some healthcare technology firms. And what they were interested in doing was creating a shared provider directory. So each individual insurance company is required to keep a directory of the providers covered by their plans. Each insurance company, each payer does this independently. And so there's lots of redundancies across the industry in maintaining this data. And there's lots of errors that can occur because the data has to be confirmed with each healthcare provider multiple times across each insurance company over the year. So the idea is that by creating a shared database for these for this particular set of information, that we can reduce these redundancies, we can reduce overhead, and we can reduce errors that occur in this data. So this was a long known problem within the healthcare industry, and the reason why it was not addressed until now is because none of the health insurance companies wanted to be reliant on a central entity who is data for providing their services. And so they're looking to blockchain as a new avenue for finally addressing this problem. So things you can see here, again, they're trying to get this coordination. They're thinking about the local control in order to solve the holdup problem. This particular example doesn't touch on the commitment issue, but they're hoping that once they build out this one use case that perhaps in the future the platform, the DLT, can be used in other ways, and perhaps they'll get to other value added through that. So generally, you'll hear things in the space like DLT provides transparency and auditability, that we can verify this digital information that we have, and we can reduce friction. So there are a lot of benefits, but as you might be able to tell, this can be a two-edged sword. So it's great that we can have this shared database and share information, but sharing information can also be problematic from an antitrust point of view. Automating things can be a problem from an antitrust point of view, depending on exactly what it is you're automating and how. And so those are the issues that we're going to dig into through the main portion of this presentation. But just before we get into that, I just wanted to highlight, we at Prism Group think of these blockchain systems as being economies or markets that are written into code. And all of the elements of how they function are designed by the consortium or the engineers who are creating the platform. And the different design elements are going to have an impact on both whether users want to join, whether participants want to come to the network, and how those participants are going to behave once they arrive in the network. And so a really important thing to understand when we're analyzing whether a DLT platform might be implicated in some in antitrust type behavior or anti-competitive behavior is understanding exactly how that system is designed. And so we think that this requires doing a robust analysis. Economic analysis on this requires not only economic expertise, but you really have to have a clear understanding of the underlying technology and when the system is being set up. And so we're going to be talking about that quite a bit as we move through the content. So the main three design levers that we're going to be looking at today are how data is shared, who data is available to within the system, how smart contracts are designed, and how standards are designed and managed. All right. Great. So data information exchange design decisions within DLT networks can be quite complex. So in public networks like Bitcoin, all of transactions are available for anyone to see, but a blockchain system does not have to be designed that way, and there can be many protections on the data limiting who can see what. And so a thing that we would want to know if we're concerned about data sharing in a DLT network having antitrust implications is what information is stored on chain, what's stored off chain, and who can see what. So these are just several levers that may look different across different networks. So in some networks, we may be storing everything on chain. All the information about price and quantity could potentially be stored on-chain. In other networks, they might decide that they want to store everything off-chain and only store hashes of the relevant information on-chain. And so there could be significant differences in terms of what is even stored in the blockchain itself. Now, even if we have all the information stored in the blockchain, that doesn't necessarily mean that that information is going to be accessible to all of the participants in the blockchain. So there can be different levels of encryption, for example, that may allow only, so if you have, we have a blockchain that contains all these transactions of many different participants. And if we're looking at the blockchain, we might only see records that transactions happened, but I might not be able to tell that who was a party to a specific transaction or how much was transferred within that transaction unless I'm one of the parties trading in that specific transaction. And so we can have the data be encrypted in a particular way that have conducted this transaction, can those two individuals see the content of that transaction? We won't go into technical details about how encryption works, but there's also research being done into how to allow a system like that to, for example, be available for auditing, even if the data would not be available to other participants within the system. So there are ways to allow the data to be stored on chain without allowing sensitive information to be viewed by competitors, for example. And relatedly, related to the encryption piece is this idea of zero knowledge proofs. So essentially what zero knowledge proofs do are allow an outsider to ask a yes or no question about a specific transaction or, for example, an account balance. So you might want to demonstrate that a specific transaction that took place was not above $10,000, for example, and you would be able to do that using zero knowledge proofs without having to reveal the actual amount of the transaction. So there's lots of technologies available around encryption and a lot of different choices that a platform designer can make around which data is going to be available and to which participants. And we think that all of these design levers are going to be very important when thinking about whether the use of a system could be implicated in something like collusion.
Can you hear me now? All right, I apologize for the technical difficulties. Okay, so let's continue. So so when assessing the anti-competitiveness of potential information sharing across a DLT network, we want to look at the levers that I just mentioned, and we also want to think carefully about, you know, what information is potentially being shared and who is seeing this information. So so we've made a list here of the types of questions that we would want to ask of the particular context that we're looking at. So we want to think about, what is the source of the information? Is this information that's coming from other competitors? Is it information that's coming from customers? What's the nature of the information? Is it the type of information that would typically be competitively sensitive, like pricing information or quantity information, versus more or less sensitive information, or more aggregate type of information? What's the time frame on the information? Are we talking about of current information, or are we sort of looking at more historical information? And then we want to look at how those things sort of interact with the permissions that are allowed in the system. So are competitors being allowed to view each other's transactions and perhaps monitor things like price, or are competitors sort of being blocked from viewing that aspect of transactions, and the system really only being used in order to reduce reconciliation costs between buyers and sellers. So again, we believe that that these systems can be set up in ways that really service these legitimate business concerns, but sort of as they're being set up, there are potential ways that collusive behavior could be allowed, and those things need to be looked at carefully. So the next issue that we think about is smart contracts. So smart contracts are essentially algorithms that are going to automatically or digitally execute agreements, such as transactions. And we know from precedent that algorithms could be used in a way that facilitates collusion. So United States v. Tompkins is an example of a case that hinges on the use of algorithms basically in order to fix prices. So this same concern might be present in the context of smart contracts, depending on exactly how those smart contracts are used. So as I mentioned, you know, smart contracts are algorithms that are going to automatically perform some type of action, and they do that as they read in information that can come from on the blockchain, or information that can come from outside of the blockchain. So as an example, AXA, the insurance company, created kind of a fun consumer insurance product for travel, and it hinged on smart contracts where if your flight was more than 4 hours late and you had purchased this type of insurance, then the smart contract would automatically pay you the amount that you were owed. And so it would read in this information about whether the flight was late or not, and that's coming from off-chain data. The benefits of having excuse me, the benefits of having a smart contract are that basically we don't need to rely on a third party's discretion, or even the discretion of one of the two parties to the contract. We can perhaps lessen the cost of one or both of the parties to having the contract fulfilled or having the agreement go through. For example, in the travel insurance example I gave, consumers or folks who had bought this insurance wouldn't have to file a claim. So it makes it much easier for them to know that they will be reimbursed in the event that they're impacted by a travel delay. So there's certainly potentially value there. And this can potentially reduce the frequency or incidence of disputes between parties, again, over these particular clauses that would execute the contract based on objective information. So smart contracts are certainly not a panacea for all contracts. They can only be applied in these contexts where the agreement relies on information that can be digitized and then read into them. So this relates to the feature of blockchain that we talked about earlier, commitment, that one of the really important key elements of the smart contract is that it's immutable in a way that neither of the parties can basically stop the contract from executing if the conditions for execution have been met. And that's what gives this its value in the context in which it can be used. But as I mentioned, because these are basically just algorithms, they can be used for good, or they could be used for potentially in collusive arrangements, or for anti-competitive reasons. And so we want to think very carefully about exactly what is the content of these smart contracts. And so we want to look at, who is a party to this smart contract. It's probably going to be pretty safe if it's a buyer and a seller that have this smart contract. We want to be cognizant that if we have set up a blockchain or distributed ledger platform, that it may be possible that competitors decide to use smart contracts with one another. So that's something. We also want to look at what's being specified in the output of the algorithm. So in the example that I previously gave, the amount to be paid to the customer of the insurance is something that's specified in advance. That doesn't change as a result of conditions that are read into the smart contract. But you certainly could write a smart contract whose price is determined based on information that's read into it. And so that might be something that requires a little bit more scrutiny depending on the context. So we want to think about sort of what are the outputs of the algorithm. Is it determining something about price? Is it determining something about quantity? Or is it simply just executing the trade? And then we also want to think about what are the inputs to that algorithm. Is it just reading events like this flight was late, or is it reading information about prices elsewhere in the industry? Is it reading other information, potentially sensitive information? Those are all things that we would want to look at carefully. All right. And finally, we want to think about standards. So it's important to understand that all blockchain or DLT platforms are going to require data standards. There's been a variety of antitrust cases that have involved in industrial standards or implicated industrial standards. A couple of examples are Allied Tube and Conduit Corp, the Indian Head Inc., American Society of Mechanical Engineers v. Hydro Level Corp. So, I think in particular, standards may be a concern because they could basically cause a restriction in the market, or sort of make it difficult some potential participants or entrants to participate in the market. So we want to think carefully about both how the standards are set up and how they're used, or sort of who has control over them in an ongoing way. There's a variety of issues we think about as a DLT is being set up in terms of its standards. And in particular, it relates back to the issue of holdup and potentially locking participants into the use. Once an entity has put their data into a particular system, or converted it into a particular form in order to participate in this shared database, they might then have difficulty re-accessing their data without having to rely on the same database provider. And so it's sort of like, if you write a document in Word, you want to know not only that Word is going to be available to you so you can continue to open that document, but you might want to make sure that you can convert that Word document into a different format, so you might be able to open it with a different program. It's basically the same idea. Just because you have a piece of data doesn't mean necessarily that you can access or you can read that data. And so the standards that would allow the different participants in a blockchain to share data and to be able to talk to one another can also create a situation where one entity has difficulty accessing their own data. So we want to think about how, usually we would want to make sure that these the most basic part of the standard is going to be open sourced and accessible, as opposed to being proprietary. But there's sort of different levels. So data standards can be quite narrow. They can be very broad, and it may be that different parts of that are open versus closed. We also want to think about the intellectual property and the management of the standard over time. So certainly as a platform grows, as it develops new features, it may be that a data standard needs to be expanded in order to facilitate those added features. And we want to think carefully about who's involved in the process of expanding a standard, who gets to make decisions about what the standard consists of. It may be possible for some participants to gain an advantage by creating a standard that sort of works very well with their existing systems. In order to, if we're thinking about a new DTL platform and trying to gain participation and avoiding the holdup, we want standard to be, for example, based on a standard that's already been in use in the industry. We want it to be open source, things like this. But as the platform develops, as more folks join it, circumstances can certainly change, and different participants in the system could become more reliant on these data standards and the software that's employed by the DLT. So we think it's certainly something to keep an eye on and to understand carefully how these data standards are formed. These are the types of questions that we would want to ask around what the data standard looks like. So, are we using an existing standard? Did we start something from scratch? Is the standard narrow? Is it broad? Licensing arrangements around the standard, both whether it's open versus proprietary and what the licensing scheme might look like if parts of it are proprietary. And I think that we also want to think about sort of how the system evolved over time. Again, a network is always going to start with only a small few participants, but as it becomes bigger over time, this can have an impact on the competitive nature of folks who have not participated in that platform or in that consortium, if they're only one of the few who's not using a standard that's used by this large platform. So again, whether it's the information sharing, the smart contracts, or these data standards, all of these are tools that we think are important in order to facilitate the efficiencies that can be gained through the use of blockchain or distributed ledger technology. But they all sort of have these potential pitfalls or problems and areas that might be investigated for potential anti-competitiveness or collusion. So, skipped a slide. Okay, so very briefly, and I'm going to open up in a moment to Q&A. We did just want to discuss very briefly calculation of economic damages. In particular, what I really wanted to highlight here is that the blockchain space and this industry is a bit unusual compared to other industries because of its decentralized nature. And in particular, the iFinax, and we thought that this case was very interesting because there was an allegation in the case that the defendants used basically monopoly power or collusion in order to control the price of Bitcoin and other cryptocurrencies. What was interesting about this allegation is that neither of the defendants were, the issuer of Bitcoin or the issuer of these other cryptocurrencies. Was a stablecoin issuer and a cryptocurrency exchange. And so, these aren't sort of your run-of-the-mill allegations of price fixing within an industry where you think that a couple of the producers of a particular product are fixing the price of that product. The allegations here could be much more complex. I won't go into the particular merits of this case, but on the face of it, it's possible that these allegations could be true. They should actually be investigated at a deeper level. It's not the case that just because these defendants weren't the issuers of Bitcoin, they couldn't possibly fix the price. It's a more complex issue, and so we wanted to highlight that the analysis in these cases might look a bit different than what you would normally expect to see in an antitrust case. So just summarizing and wrapping up before we open up to questions, what we really wanted to highlight for you is that DLT has this potential to really improve the efficiency of businesses and consortia. In particular, it solves some of the problems around shared databases for enterprises. But in solving those problems for sharing data, there is also the potential to open up avenues for collusive behavior or market restriction that might be implicated in antitrust cases. And so we want to think carefully about which aspects of these systems should be examined to determine if antitrust behavior might be occurring. In data exchange, we want to look at how different encryption tools are used and who has access to which data. In smart contracts, we want to look specifically at what algorithms are determining their outputs. And in standards, we want to look at sort of how these standards are being constructed and how open or closed the standards are. There's obviously a variety of aspects of antitrust law that could be potentially very interesting, or could result in a lot of discussion or research about sort of specific issues. But this is sort of a high-level overview of where we think these systems should be scrutinized in order to determine if there are potential problems from an anti-competition point of view. So with that being said, I am happy to open the floor to questions. Okay, so I'm reading the question and I'm going to read it out loud. So the question is, once an enterprise consortia gains scale and takes off, it seems that it might be unavoidable that there will be claims of a consortium using blockchain to exclude others. Is that the probable case? And then there's a follow-up question. So I'll start with that. I think that is certainly a possibility. I think that it depends a lot on the specifics of how the system is set up and what exactly the system is used for. So for example, if it's a trade platform and the only way that you can gain access to trading partners is through the platform, that might be problematic. But that would also depend on sort of what are the criteria for joining the platform. If the platform is free to join, for example, and it's just being used as infrastructure in order to execute trades, then this might not be so much of a problem. So I think, this again, I think highlights why it's really important to understand how these systems are being set up, as well as sort of the monetization strategies that are being used by the, say, founding members. And the follow-up question consortium can use, I guess, to think about whether it's reaching the scale is excluding others from the market. Again, I think that we just need to. You would need to examine on a case-by-case basis and think about what are the criteria for membership. Are membership fees being charged, or are there sort of services added on top? Are there other ways to gain access to the market? What is the platform being used for? And so I think it really needs to be determined on a case-by-case basis. Are there specific industries that are more susceptible to this risk? I think that, sort of as I mentioned, I think that this is probably more of a risk where the platform is being used to execute trades rather than to share information. So the example that I mentioned at the top of the talk about creating a database of providers in the healthcare industry, I think that is likely to be viewed more as a resource, as opposed to preventing someone from being able to access the market. Whereas if a platform is being used to conduct trades between buyers and sellers, and the only way that you can execute a transaction in this industry, or the only way that you can access, for example, buyers in the industry, is by accessing the platform, then that's more likely to be problematic. But I don't think that there are sort of hard and fast rules. So I have a question here about, based on the early state of the technology, what is the time horizon for antitrust case to begin or peak? I'll speak a little bit about the state of the industry. I leave it to the lawyers to have more insight into to be brought or when this legal action should be taken. I think that it's true that the technology is still in relatively early development. That being said, you know, in industries that are already relatively consolidated, it might not take much, you know, only a couple of sort of creating a platform together to cause among other competitors in an industry. So I really think that it depends a lot on which industries you're looking at, where it's being applied, and how much consolidation is already in the industry. In industries that are much more fragmented, much less consolidated, it's clear that a particular platform would have to gain many entities or many users before it would sort of have sufficient market share to be concerned about applying that kind of market power. Although, you know, you could still have firms colluding together potentially within a platform on a smaller scale. But I leave that to the lawyers to determine what is problematic from a antitrust law point of view. Next question is, from an economics perspective, is there a particular industry that may be more or most exposed to antitrust risks? That is a good question. I think that a particular industry, no, I wouldn't say that I think that there's a particular industry that would be more susceptible to the types of issues that we were talking about today. As that, you know, the issues that we went through are issues that could happen in any industry. You know, sharing of sensitive information is something that competitors in any field could do. Using algorithms to do something like manipulate price, given the quantity of data available in the world these days, is sort of something that could happen in any industry. So I don't think that there's a particular industry that might be more susceptible. That being said, I think that, as mentioned before, industries that are concentrated might be able to get to scale with for this kind of collusive behavior to have an impact faster than industries that are more fragmented. The next question is, how much research is needed from your end before you as an economist can confidently say whether or not you can add value to my legal case? We can do that pretty quickly. It depends on the case. We've done, so typically we will do just an initial small retainer. We'll be able to tell you by just looking at the basic information that you give to us, how long that initial retainer would be for us to sort of assess what we can do. Usually it's along the lines of it can be as few as 10 hours. I would say 10 to 20 hours. If it's, 20 would be something that would be very complicated, just in order for us to assess the situation and see what kind of more in-depth research would need to be done in order to make the case, essentially, from an economics point of view. I see we're running up on time. All right. So thank you, everyone, for joining today. I welcome any of you who would like to follow up with me if you have specific questions about a case that you're looking at. My email address is here. It's kathy.barrera@prismgroup.io. I would be happy to talk to you about more specifics. The recording will be made available, and we have another webinar coming up on ICOs and securities law on April 29th. And Stephanie Herder will be heading that one. So we hope to see you all there. Thank you very much for joining, and have a great afternoon.